Well, it's interesting, isn't it, Chris? Because I think we're seeing a lot more landlords wanting to get rid of freeholds at the moment because of the proposed legislative change. So the Leasehold and Freehold Reform Act 2024 is on the statute books. It's not yet in force, but the government's been tightening the screws around leasehold for a while.
Welcome to Listen Without Prejudice, your exclusive gateway to one of London's leading law firms. In each episode, we dive deep into the stories, insights, and expertise that make Bishop Sewell a trusted name in the legal community. Join us as we explore everything from the latest legal trends and case studies to practical advice on residential and commercial property, corporate and commercial law, employment, family and divorce matters, private clients, and dispute resolution. Whether you're a legal professional, a client, or simply curious about the law, Listen Without Prejudice is here to inform, inspire, and engage. Now, without further ado, let's get the conversation started.
Good afternoon. So my name is Chris Macartney. I'm head of Landlord and Tenant at Bishop Sewell, and with me this afternoon for the show is Mark Chick, my partner, who also heads up the team, senior partner of the firm. We're here today to speak to you about Section 5s under the Landlord and Tenant Act 1987, their impact upon residential property, how they are affected by the impending legislatory reform from the Leasehold Reform Act 2024, and what properties are affected by them, and what disposal means, and what the purpose of the Act is. So, Mark, why are we talking about this at the moment?
Well, it's interesting, isn't it, Chris? Because I think we're seeing a lot more landlords wanting to get rid of freeholds at the moment because of the proposed legislative change. So the Leasehold and Freehold Reform Act 2024 is on the statute books. It's not yet in force, but the government's been tightening the screws around leasehold for a while. And over the last 3 to 5 years, we've seen various portfolio landlords decide it's time to get rid of some of their assets. So we've seen an increase in these sorts of disposals. There's also been a bit of uncertainty around ground rent. There's been talk about reforming the law in relation to that. So it's led change across the sector. So we've seen lots of people thinking now is a good time perhaps to divest themselves of some of these assets, which is why Section 5 notices, Section 5A, Section 5B, have become more prevalent, I think, in recent times. I mean, Chris, you and I both know this, but I mean, the 87 Act's a bit of a gift, but it's also perhaps a little bit of a curse as well. It's an interesting piece of legislation, isn't it?
It is. It's known by some as the worst drafted piece of legislation for property law. It is very widely drafted in some respects. It's a bit of a catch-all piece of legislation. It does feel like there wasn't enough thought given to certain parts of it when it was put onto the statute books, but we've been stuck with it for the last however many years. It does the job, and it certainly keeps us busy enough. So, I mean, we're generally referring in today's talk about the disposal of an interest, typically a freehold interest, probably under Section 5. We've talked anecdotally about Section 5 already, and some people may not know what we're talking about, of course. The Act does do various other things as well. So it also deals with appointing managing agents where the manager's not working out in the building properly. If the freeholder is in breach of his covenants under the lease, there's very useful provisions there in acquiring the freehold where the landlord's missing. We've talked a lot about the other piece of legislation. Well, let's focus in on Section 5 for now. What does that mean? What does that involve?
Okay, well, I think the first thing to think about, Section 5 covers disposals, getting rid of things, as we've just said, so selling a freehold or selling perhaps a leasehold interest, which this legislation applies to. And that's any freehold where you've got long leases, so long leases of flats, and certain other qualifying leases. There can be certain kinds of assured tenancies, and other tenancies will also qualify. And the Act makes it a criminal offence to get rid of one of these types of assets without first offering it to the flat owners under the so-called Right of Frist Refusal under that Act. So I guess that's the first thing to think about. It's a clearance mechanism. If the owner of the freehold or the head leasehold interest wants to sell it, they've first got to go through this step before they can send it somewhere else. And there are two possible routes we could be talking about. There's Section 5A, which is be a fixed price, and Section 5B, which would be to do with an auction, both of which come with their own interesting steps and complexities.
Right. Okay. So, for example, if somebody's looking to dispose of an interest, sometimes they can find a buyer and then think, right, well, okay, we've got this interest, I've agreed a price for it, what do I do now? Mark, and you will then speak to the client and say, well, first off, we need to offer this interest out to all of the long leaseholders to which the freehold is subject to see if they want to acquire the interest. So are there any transactions that are not triggered by the legislation?
Well, there are a few exemptions, aren't there? So there's a couple of situations where if there's an associated company that's been an associated company for the last 2 years, that won't be caught. A disposal of the shares in the company that owns the freehold won't be caught either. So one of the reasons you said earlier on about this being a curiously drafted piece of legislation, because some things almost allow you to get around the Act. There's also a large number of exempt types of transfer. So if a freehold's compulsorily bought under the 1993 Act, that's obviously not in contravention of this. If you change trustees or owners or make a disposal between family members, there's also an exemption there. And there's yet another exemption where someone is a resident landlord. So if they live in the property and have lived in it as their principal residence for a period ending in 12 months from the time that they get rid of it, they're not required to notify in the way we've been talking about. But in the vast majority of what you might call standard cases where an exemption doesn't apply, some kind of notification has to be given.
Yeah, indeed. And it's fairly strict. If you haven't dealt with that, then the remedy is, you're committing an offence. Although I'm not sure if anybody has actually ever been prosecuted under it.
Prosecutions are rare, aren't they? They're done by dealt with through the local authority level, but it is an offence. It's a level 5 fine on the standard scale, I think. But prosecutions are extremely rare, mainly because people comply, and because, of course, the flat owners have other remedies as well, don't they?
Yes, they do. There's the reasonable excuse as well. I think there's a provision in it that provides, in the 1987 Act, that provides that if you have a reasonable excuse for not having served notice, that you have not necessarily committed an offence. But I don't know many people that would ever want to rely upon that. And I also don't know, it's not like you would start advising your client, say, well, just ignore the legislation, commit an offence, get on with the transaction anyway, because, who's going to do that? It's not a particularly sensible course of events.
No. As professional advisors, we can never really advise the client to do that, clearly, and we're never going to.
No, indeed. But there are some circumstances where it does feel slightly unusual that you need to comply with this piece of legislation. For example, where you have, 3 people in a building have acquired the freehold and they own it in their names, and then one person is selling their interest. In those circumstances, you might have to serve Section 5 notice. Or if there are 3 flats in the building or 4 flats in the building and one person didn't participate, would you then need to serve the notice again? The legislation says you do, but you're just delaying a conveyancing transaction by 2 months for the hell of it.
Well, that's right. And I think we've also seen that other situation where perhaps there are only 2 or 3 flats in the building the freeholder wants to sell, the leaseholders want to buy, and yet these notices need to be served. Although the only people that could really object would be the leaseholders, who, in theory, at least would have to wait 2 months before they could do anything.
Yeah, and I have certainly had circumstances where the freehold has been registered in the names of individuals, and one of those leaseholders is holding everybody else to ransom for a sum of money before they'll sign it. So, it's an interesting piece of legislation. So we've been talking about Section 5, the different types of disposal. We've discussed the Section 5 sale by contract, and we've touched upon Section 5 disposal at auction. What we haven't talked about is what the process involved is for both of those and how long they might be. So
it'd definitely worth saying a few words about that, wouldn't it, Chris? Definitely, because I think, once we've mentioned this 2-month period, so if you want to sell of a freehold or another interest that this Act applies to, you have to notify whether it's a Section 5A or a Section 5B. Let's stick with the 5A route at the moment, where you've got a fixed price in mind that you want to sell for. So you serve a notice, Section 5A offer notice, notifying the flat owners if that's what you plan to do. They've got then 2 months to accept that notice. And if they accept, it would need a majority. So more than half of the flat owners would need to club together to serve an acceptance notice. And if they do that, then they get themselves booked into the next phase in the game, if you like, which is serving what's called a nomination notice. And Chris, I think you know what a nomination notice is.
Yeah, indeed. So notice of nomination is the notice that you serve nominating the legal individual to whom the freehold is to be transferred. So that can be a corporate individual, set of private individuals, or a trust, for example, something like that. But generally speaking, it's depending upon the size of the flat, it's size of the block, sorry, it's usually a company or
Yeah.
set of
I
individuals.
mean, we'd normally use a company where
Yeah.
there's maybe any more than 3 or 4 flats. Certainly, would be the best way forward, wouldn't it?
Absolutely, yes. Because in England and Wales, you can only hold legal title to property in a maximum of 4 names. So if you've got 4 flats and there's one person there that owns it jointly with partner, spouse, whoever, then obviously you're going to be over 4 names pretty quickly.
Yeah, absolutely. So there's no requirement, but you need to nominate somebody to take the transfer of the interest at the end of the day.
Yeah,
And then what happens next? Then we've got to get a contract, haven't we?
So the contract, yeah, indeed. So you've got 2 months to accept, 2 months to nominate, and then the landlord has 28 days within which to provide a contract. If they don't provide the contract by the end of that 28-day period, they've automatically withdrawn from the process and they have a liability for costs. It does happen that landlords aren't necessarily that up to date and don't keep up to the timeframes. So typically, a group of tenants aren't usually going to do much to the landlord if he's a short period of time over that deadline, although it can be quite useful to persuade them to act a bit more quickly if you tell them that they suddenly have picked up a liability for your own costs.
Maybe it's important to point out that this process isn't binding until a contract's actually been exchanged. I think that's important as well, because some people see this as being a contractual right. It's a right to get to an exchange of contracts, not exchanging contracts itself.
Exactly. You can't force anybody to buy something until they take the step to do it. So, as a group of tenants, you could do everything that's expected of you. So accept and nominate and then offer up an exchange of contracts in the parlance of the legislation. If the landlord doesn't accept that offer of exchange, then, you don't complete and they've withdrawn from the process. There is a liability for costs, as I said, but it's only from the second month of the 2-month period
Exactly, it's
of
after
nomination.
the start of the second, the 4 weeks into the nomination period, isn't it? So there's that's a penalty, but one that's not a significant penalty against pulling away from the transaction. And we mentioned Section 5A, the fixed price route. What about Section 5B then? So that's where we've got an auction.
Yeah, Section 5B is the right to buy the interest for the price that it sells at auction. The timeframes are similar, but slightly different. So you have 2 months again to accept the benefit of the notice using the Section 6 procedure, 6B. You then have 1 month to nominate. And then following nomination, you have to serve a Section 8B notice confirming that the provisions of Section 9 will apply to the disposal. And if you don't serve that, you've withdrawn from the process and they can sell it at auction without offering it to you. So assuming that you do all that and it sells at auction, then at the point that the hammer falls and the interest is sold, the landlord then has 7 days to offer the contract to the people who accepted and nominated to give them the opportunity to buy it for the price that it's sold for at auction. So again, you're not bound to complete. So from the point that you have the contract, you then have 28 days to offer up an exchange of contract. So if the landlord is selling it at auction, it's a slightly more
28 days
constrained.
to get to completion, isn't it? Because you've got to follow the standard auction conditions, which normally require completion within 28 days. So I think it's important that anyone looking to go down that route organises themselves well in advance, because if the amounts of money involved are not trivial, they need to have all that funding in place to be able to not only bid, but know that they're going to go through with the thing, having been a successful bidder at auction or having the right of first refusal against that bidder.
Yeah, exactly.
So there's quite a few things to think about. And there's also structuring the transaction as well. That's something else we often get involved in as well, isn't it?
Yeah, indeed. So, it's if you're acting for a landlord who wants to dispose of something and not make it particularly attractive to tenants, say, then, there are ways and means of doing that, depending upon how you structure and draft those, the offer notice. If you can conceive of it being in such a format that it's unattractive to the other tenants, then you can not get around the legislation, but make that transaction such that the tenants are unlikely then to accept it, so that you can go ahead and dispose of the interests in the way that you conceived before you started the process.
Perhaps also worth thinking about the fact that you've got to buy the whole of the freehold as well. It's not as if you're, you think, oh, I've received this notice, I'd like to take part. It sounds like a great idea. Indeed it is. But you're going to take part with other people, so you need to be part of that majority. Then you've got to ask yourself, what's going to happen to the cost of the people that didn't take part, because that has to be funded by those that did. And there are no rules or laws about how that's organised, but people have to organise themselves around that. We have lots of different suggestions about how people might do that in practice. Probably something for another show.
Indeed. Absolutely. There's lots of ways, means around this to make sure that it works properly. The important thing that you mentioned then is making sure that people act collectively, because there are people that I have spoken to on the phone in the past who have said, well, I wrote to the freeholder saying I accept it. Well, okay, that's fine. But if you did it on your own, you're probably not going to comply with the strict wording of the legislation. So you need to act in concert with other leaseholders in your building so that a majority, and last time I checked, a majority is not 50%, it's more than, accept the benefit of the notice. So that's an important thing, I think, to make. You know, a landlord may not want to make it easy for you to accept the benefit of the notice because they may already, for commercial reasons, have found another buyer for the interest.
Absolutely. And what about buildings themselves as well? That's another thing to mention as well, because it's not just necessarily straight blocks of flats we're talking about. Some mixed-use property will be caught by this as well, won't it?
Yes. So the difference between the Landlord and Tenant Act 1987 and the Leasehold Reform Housing and Urban Development Act 1993 is that under the 1993 Act, a property which has more than 25% of the premises being non-residential use won't qualify for 1993 Act purposes, whereas under the 1987 Act, it's 50%. So there's a big difference there, which of course is likely to change under the Leasehold Freehold Reform Act 2024, but we'll get on to that.
Yeah, indeed. And I think it's also perhaps worth touching on what is a disposal as well, because it might sound obvious it's selling the freehold or perhaps the head leasehold interest in a building. But other disposals can be caught as well, and sometimes residents in their own freehold-owned blocks get caught out by this. They want to sell a broom cupboard or something which is in the common parts to a particular flat owner. That can't be done, certainly not without offering it under these sorts of rights if it's commonly held property. And of course, if it's exclusively let to someone else, it wouldn't be possible to transfer it anyway. But
that's right. So it's any property within a freehold over which the leaseholders, as a collective group, or in at least more than one person, that is, has rights over. So as Mark said, roof space, you might need access to the roof for the purposes of management, common parts, broom cupboards,
storage areas. The list goes on and on and on, doesn't
vaults,
it? So
that's always quite popular at the moment as people are trying to look for more and more space in a confined area.
Building. Yeah,
building's not getting any bigger, so see what you can buy in the building to make your flat larger.
So just thinking again about what happens, we've said a lot about the process of accepting the notices and other things like that, but what happens, say for instance, Section 5A, offer notice, if the leaseholders don't accept the notice, what will happen next?
So if the benefit of the notice is not accepted by a majority of qualifying tenants, then the landlord can dispose of that interest on the same terms that were offered in the Section 5 notice to whoever they want, which was at the beginning, we mentioned about the landlord maybe having set up a disposal with a buyer already, but then offering up to the tenants the rights of first refusal to allow them to buy it. So in those circumstances, if the tenants don't then accept the benefit of that notice, he can then go on off and sell it to whoever it is that he's found to buy the interest in the first place.
And there's clearance for a period of a year, isn't there?
There is, 12 months from the date that the offer period expires. The landlord can dispose of the interest on the same terms. So as soon as if they were to dispose of the interest on more preferential terms to anybody else, then they're in breach of the legislation, and there are steps that the tenants can take to rewind that transaction.
Let's just touch on that very briefly as well. So if someone breaches what the Act's provisions and there's a disposal which wasn't an exempt disposal, what happens?
So you can require the landlord then, or the person who's bought it, to sell the interest to you on exactly the same terms. And they would also pick up the cost of doing that as well. So you may think, well, that's a bit unfair on the person that's bought it, but they would or should have some contractual remedy against the person that sold it to them, so against the original freeholder that disposed of the interest in breach of the legislation. But you can rewind the transaction. And there are some specific steps that the landlord must take once they've acquired the interest to stop that time frame from running, which is giving notice to the leaseholder of that transaction taking place and the fact they may or may not have had rights. And if they do that, then they've got to wait a period of time, and the tenants don't then have any rights and they can't do anything about it. But so long as, if the transaction happened and they never served that notice, even if it's a year, 2 years later, the tenants can still go back and potentially acquire it for the price that it was disposed of. There's some legislation a couple of years ago where that exact thing happened, and I can't remember the exact facts of it, but I think the landlord effectively then made a further disposal, or the new landlord made a further disposal to that was again in breach of the legislation for £1 or something, and the tenants all wound back.
Yeah. So yeah,
are you about to tell me the name of the case?
No, I'm not. No,
okay.
sorry, no. there's lots of things to think about there, aren't there? So, and I think I suppose the question really would be, how does the Leasehold and Freehold Reform Act 2024 impact all of this? I should guess the short answer is not directly, but indirectly.
No. Well, yeah, indirectly, I suppose. At the moment, landlords are seeing this lacuna between the legislation having been enacted but not yet coming into force. They can see what's down the road. They don't necessarily know what the outcome is going to be, so they're making the most of the situation that they find themselves with under the Landlord and Tenant Act 1987. So they're structuring deals, offering them tenants, seeing if they can get more money now than they might do if the tenants were to enfranchise against them in the future.
Yeah, absolutely. I suppose, and perhaps just sort of in ending this sort of session, I mean, to take to the final point, I mean, if you're offered your freehold under the 1987 Act, I mean, compared to other ways of buying a freehold, how does it stack up as a thing to do?
I think it's quite an attractive prospect generally, assuming that you've satisfied yourself that the price is a good one. Then it gives you a specific time frame within which the transaction takes place. There's motivation there for the tenants to actually get themselves together, get their funding together quickly. The certainty to price, you know what you're buying quite early on, and costs or the landlord's costs will typically be dealt with in the Section 5 notice if they're looking to recover them. So it's a good outcome, I think.
So it could be a kind of, not exactly an on-a-plate offering, but it's providing the price is right, a very good way to end up buying your freehold.
Yeah, absolutely. It's a take it or leave it offer. That's the thing to bear in mind, I think. So when the landlord comes with a Section 5A saying, I'm offering to sell this interest for X pounds, then you can't then go back and negotiate that price, because if you do that and then don't accept the benefit of it, you've lost the opportunity to buy it at all, unless you go down the other piece of legislation under the 1993 Act, as is at the moment, and get them to force them to sell it to you. So that it's a good option, I think, generally speaking. There are times, what we're seeing is landlords are sometimes selling interests at the moment for a sort of a slightly higher price than they might get were they to be enfranchised against by the tenants, on the basis that the tenants know what they're buying. So again, the certainty that I mentioned previously. So it makes it easier for them to buy it. They know what they're acquiring, and it means that the landlord gets a fair amount of money as well.
Yeah, and I guess the other final tip in closing would be, if you're going to get one of these notices, you've got to act reasonably quickly, because 2 months will go quite fast. If you don't know your other neighbouring flat owners coming to see us the day before it needs to be accepted, it's not something we can generally help you with.
No, I mean, we'll do what we can, but if you've got a block of 100 flats and you come within a week to accept, it's going to be pretty difficult for us to be able to act for you, to be able to onboard that many people. Well, realistically, actually get around enough people to say yes, because of course we could do the work, but
yeah, but it's having those people instructing us, isn't it? And that's all going to take a week or two at least. And that's assuming we've got nothing else to do, which isn't always the case.
No, exactly.
Sometimes we're quite busy.
Yeah, exactly. So in terms of the costs and the process of the 1987 Act in comparison to the 1993 Act, how does that tend to stack up?
Well, I think that because the transaction's set in terms of the price itself on offer, or you're going to accept the auction route, I think from our side, and you probably agree with this, transaction, it's easier to be clear about what the costs are like to be, because you're unlikely to go to tribunal. So, and you may not be paying the landlord's costs. They may be written into the notice, but the 87 Act, unlike the 93 Act, does not have a baked-in provision. So that's good news as well. So there can be some savings. So cost-benefit wise, it's providing the price is right, very good opportunity for flat owners.
Yeah. We should probably mention the fact that there are other provisions under the Section 5 Act which allow you for the landlord to dispose of the interest. There's the Section 5C, which is for disposal by non-monetary consideration. I think I've never seen one of those.
No, I haven't. No.
And Section 5D, which is a straight transfer, so there's no contract. But again, that just doesn't happen very often.
So it'll be a very simple transaction for that to happen.
Yeah, exactly. Yeah. Generally speaking, most people will serve a Section 5A notice. And I think the legislation, as it is drafted badly, as you will remember at the beginning, doesn't deal with the procedure as well as it does with the Section 5A and the Section 5B procedures, which tend to work a bit better. It's probably another thing's worth saying. So if somebody's served a Section 5A notice and they don't get a buyer for it, they can't then serve another Section 5A notice to dispose of the same interest. You have to wait a year for that to
They've
expire.
got the clearance, so it is clearance for a year. It's not sort of, let's have another go with something else.
Yeah. What I've seen in practice on occasion is that the landlord has served the notice. There has been a negotiation. Ignore what I said earlier about no negotiating, and they have then got to agreement on a price, and then they have had to then serve a further Section 5A notice. Then on the basis that the tenants then want to accept it, they're not going to go back to the landlord and say, sorry, this notice that you've served on me that we want to accept
at a
and
lower
buy,
price.
it doesn't work, because there would be madness. Who would do that?
No, indeed. There we are.
So there we go. I think that's broadly speaking. I mean, we could probably talk about tales from practice under the 1987 Act until it gets dark, but we're not going to.
No.
So I think we'll call it a day on that for now. Thank you very much.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.